Good day, Crime Talk aficionados. Let's get straight to the docket today. First, I told you the defense is trying to cut a deal in the case of Bryan Kohberger. Karen Reed's attorneys continue to battle for a dismissal in her case. Ashley Benefield gets to find out where she gets to reside during her appeal. A man gets 475 years for dogfighting and animal cruelty. A weird twist in a suspicious death case in Louisiana. The Teacher of the Year in California takes a plea deal. I bet you can guess for what. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and yes, you can check us out as well on any of your favorite podcasting apps. And let's talk about CrimeTalkSearch.com. Go there today, sign up for that background subscription service, because when you do, you can do as many background searches on anyone here in the United States while you have that subscription. And here's the beautiful thing. You can cancel at any time. So whether you want to do one search or 1,000 searches, you can do it. And you get a report literally done while you wait, and it is emailed to you, and it's going to have all the information that you are curious about. All their background information, their social media presence, their criminal history. Do they own property? Do they have judgments against them? Do they have to put themselves on one of those public registries? You know what I'm talking about. All the things you need to know. So you can decide whether somebody should be coming into your life, or maybe you should be running to get those people away from you. Go to CrimeTalkSearch.com. You're going to be happy you did. All right, let's go ahead and get to the docket for Friday, February 7th, 2025. So you may recall, several weeks ago, after the motions hearing in the Bryan Kohberger matter, I said, I believe that behind the scenes, the defense is going into mitigation mode and they're trying to cut a deal. And that deal would probably include pleading guilty to all 4 counts in the Bryan Kohberger case, as well as the burglary count. In exchange, the state would drop the death penalty. Now you may say, Scott, what has changed your mind about that now? Well, first, we know that there are a couple of things. We know, obviously, Bryan Kohberger is the suspect in the quadruple murder for the University of Idaho students, right? And we know that he has a trial coming up this spring and summer. And we know that the judge has denied many and is going to deny more motions against the defense. And so now the defense, things are getting serious. They either have to start seriously going into trial preparation mode, and they also are in the mode of trying to cut a deal. What is the deal? Usually in death penalty cases, it's save my client's life. That's what the goal is. Yes, you would love to win the case, but that is a big table that you have to run to get there. Very, very difficult, because the evidence is usually pretty significant if the state feels they are going to go with the death penalty. And so how do we know that that could be taking place? Well, we know for a couple of reasons. And the first one is, obviously, first reason is that what I just mentioned, things are getting serious now. But second, there is a protective order. And a protective order is an agreement or an order by the court saying very limited people, and it normally involves the attorneys on both sides and any investigators or professionals engaged in the case on both sides, gets to have access to certain things, and that they cannot disseminate that information to any party that's not directly involved in the case. So the protective order says you must not reveal this information. If you do, you can be subject to contempt. And what do we know? The judge unsealed a protective order in this particular case. Even though it was originally sealed, the judge basically said that there's no compelling basis to keep this protective order in and of itself sealed. Now understand, the contents of the records of the protective order are going to remain confidential, and that's fine. But what we do know is these are mental health records that were initially handed over on January 9th of this year, almost 2 months after Judge Stephen Hippler ruled that Bryan Kohberger can face the death penalty. So why would the defense be turning that over? Once again, mitigation. Here's all the reasons. Look at my client's mental health history. Here's issues maybe family has had. Something's not wired right. Somebody's broken. Please consider this, take the death penalty off the table. Or the second reason is defense experts are going to rely upon this and they have to turn this information over to the prosecution because it forms the basis of their opinion, whether it's for the defense case in chief or ultimately for mitigation if it gets to sentencing. I do believe it is for mitigation purposes. We'll have to wait and see. Like I've said in the past, I've only done one death penalty case, and frankly, we got them to take death off the table. So it can be done, but it's a mitigation mode. You're saying, spare my client's life. You can't get a death penalty because of all this mitigation. So let's just cut to the chase. Either take it off the table completely or let us plead guilty to the charges and take the death penalty off the case. This is why it's so important for the courts to disclose this information. I understand there's a reason to keep certain records private, but we should know, the world should know what is taking place, and then we can figure out what it actually means, which is going on in the case. The public has a right to know. So nice job for the judge allowing this protective order to be unsealed. Next on the docket, Karen Reed's attorneys are continuing to fight to have her case dismissed. That's right. Obviously, Miss Karen Reed is facing multiple charges, including second-degree murder and the death of her boyfriend, former Boston police officer John O'Keefe. And prosecutors allege that Miss Reed struck Mr. O'Keefe with her car after a night of drinking and let him die in the snow. Well, Ms. Reed's defense has argued and presented a trial that they believe that Ms. Reed is being framed by Mr. O'Keefe's friends, former police officers or current police officers themselves, and that Mr. O'Keefe was attacked by friends and a dog at that home. Now, Ms. Reed's claims of a cover-up were obviously central to her trial, and that trial ended in a mistrial back in July when they could not reach a unanimous verdict, even though there was a big brouhaha about the jurors saying, no, we had reached, not guilty verdicts on 2 counts, but you guys never asked. Well, the way the jurors were framing it, they said, we are unable to reach a decision. We're in an impasse. So everybody just thought, and nobody bothered to ask if they had reached a verdict on any of the counts, and the judge declared a mistrial on all counts. So they get to do it again, obviously subject to pending issues at the appellate courts as well. Anyway, now the defense and the prosecution have been going at it in some motions hearings over the last several weeks, and most of it had to do with expert witnesses. Now, Reed's attorneys, I wouldn't say they got a win, but the judge ruled in their favor that says they're going to allow the defense expert who testified in the first trial, a guy by the name of Richard Green, to testify in the second trial. At the first trial, Mr. Green testified that the witness, Jennifer McCabe, used her phone to search how long to die in the cold, although it wasn't spelled that nicely in the search. And anyway, that expert says that search took place at 2:27 a.m. rather than 6:30 a.m., which the prosecution says fits their theory of the case. So despite the special prosecutor, Hank Brennan's argument saying that the opinion of the defense expert is forensically and scientifically unsound, the judge said that she was going to allow her ruling to stand and that Mr. Green can take the stand. The judge said, it's clear to me that this issue gives rise to the dispute, but it's not a gatekeeper function as to whether it's, junk science or something to that effect. The judge said it is a difference of opinions that needs to be resolved by the jury. That's what juries do, right? I did it. No, I didn't. Jury decides who's telling the truth. Our expert says this. No, our expert says this. Their expert is wrong. Our expert is right. A jury decides who is telling the truth. That's the way the system is to work. And I think the judge made the correct decision in this particular matter. Now, the other issue was a video from the Canton Police Department. Now, this video in question was recorded back in January 29th of 2022 and was introduced at the first trial, but was revealed to have been inverted. So, Ms. Reed's attorney, Mr. Alan Jackson, accused the prosecution of deliberately withholding portions of that video. And they said that, we've gotten what appears to be scraps and fragments of this video from the Commonwealth that they've decided to give to us within their own time frame. And their defense is asking legitimate questions like, why are we getting this video from January of 2022, 2.5 years later? Why were some of those videos altered or manipulated? Why are they not in the proper format? Still don't have the question. Special prosecutor, hey, says we didn't do anything wrong. Frankly, he wasn't there the first time through, but he says that his office has been doing everything they can to open up their records without hesitation to the defense, and therefore no harm, no foul. Anyway, apparently, like I said, this video, a new version has come to light because apparently somebody uploaded it to their personal iCloud. Okay, whatever. Anyway, the defense attorneys said that the footage is a complete dumpster fire, and unfortunately now Miss Reed has to pay for all the fire extinguishers, which is why the defense wants the prosecution to reimburse them for their attorney's fees and their times and the time of their experts to get this done. I don't think that's going to happen, but that's just the way it goes. Now, what should really happen if there was some true intent to hide it from the defense is that there should be sanction, a discovery violation, and that's what the defense is asking for, is basically saying this is wrong and we want the case dismissed. Those motions need to be filed by February 21st, and there will be a hearing on March 4th. Now, I would remind you, why did the Alec Baldwin case get dismissed? Discovery violation by the prosecution. Barry Morphew case, why did it get dismissed? Discovery violation by the prosecution. And we talked about it just the other day. 2 cases in Denver within 2 days, dismissed cases of child abuse resulting in serious bodily injury, as well as assault on a peace officer. Cases were dismissed. Prosecution failed to turn over key evidence. The defense had asked for it. Prosecution didn't get around to doing it. Said it didn't exist. Oops, there it is. Case dismissed. Deliberate and intentional, ladies and gentlemen. Ms. Reed may get her wishes, maybe not by winning the trial, but by just keep battling the prosecution. More often than not, you see these type of cases, there's so much evidence, there's so much digital evidence. It's so hard to keep track of, ladies and gentlemen. And when jurisdictions aren't used to all of that data, well, guess what? Things get lost, things don't get turned over. And who bears the brunt of it? The prosecution. Next, Ashley Benefield finds out where she gets to reside during the pendency of her appeal. That's right, the former ballerina convicted of manslaughter is going to remain behind bars during her appeal. The judge denied her request for bond. Now, as you may recall, Ms. Benefield was sentenced to 20 years in state prison for shooting her husband, Douglas Benefield, in her bedroom back in September of 2020. Now, she claimed throughout her entire trial and before that she did shoot him, but that it was done in self-defense. A jury decided that question of fact and said, no, it was manslaughter. Anyway, on February 6th, the court held a hearing to decide whether Ms. Benefield should be allowed to be released on a bond pending her appeal. At that hearing, the defense argued that she had a very strong ties to the community, a job waiting for her, and the fact that she was on her best behavior while she was on bond pending the murder trial. The prosecution opposed it, saying it's a serious crime. She needs to remain in custody. Judge White acknowledged the testimony of the friends of Ms. Benefield and even her former probation officer, who said she was a good pretrial bond release individual. But just the severity of the case and insufficient ties to the community, she has to remain behind bars. Next, mistreat dogs go to prison for 475 years. Why am I okay with this? That's right, a man was sentenced to 475 years in prison for his role in a dog fighting operation. Mr. Vincent Lamarck Burrell was arrested back in 2020 after deputies discovered 106 dogs on his property in Georgia. The sheriff's office, where Mr. Burrell resided, executed a search warrant at Mr. Burrell's home and later found the dogs tied to fence posts with heavy chain. They also found documents linking Mr. Burrell's dogs to other known dog fighters and contracts for some of the dogs, according to the district attorney's office. Now, police said the dogs were basically left in the elements with little to no shelter and were not seen by a veterinarian regularly. Now, the dogs were also found in the basement of the home, where the presence of odor and urine and feces were quite strong, and police had to wear protective equipment to go in there. It was so bad. Apparently conditions where the dogs were being housed, both inside and exterior of the property, were not fit for humans, let alone a dog. Anyway, Mr. Burrell was convicted of 93 counts of dog fighting and 10 counts of cruelty to animals, and guess what? 475 years. You know, your animals are like your children. You have one duty: to protect them, take care of them the best you can. Not train them to be fighty dogs and to completely ignore them. Next, a very awkward twist to a suspicious death in Louisiana just in time for the Super Bowl. That's right. A woman in Louisiana with a history of drugging men and stealing their credit cards was arrested in connection with the death of a reporter from the Telemundo station while he was in New Orleans to cover the Super Bowl. So Danette Colbert of Louisiana was busted after she was captured on video surveillance leaving the journalist Aiden Manzano's hotel room before allegedly using his credit card at his store in Louisiana. She was seen in the footage leaving the 27-year-old reporter's hotel room in the suburb of Kenner before going to the alleged shopping spree. Now, Ms. Colbert has so far been charged with only property crimes, including bank fraud and theft, but she has previously been accused of drugging at least 2 men and swiping their credit cards. She apparently has a rap sheet that includes allegations of drugging men, theft of currency, fraud, fraudulent use of credit and debit cards, and other financial crimes, according to the police. And Ms. Colbert was charged with also introducing a foreign substance, into a victim in Nevada back in 2022. The other one was in Louisiana about 2 years ago. Anyway, the security footage revealed that Colbert arrived with Mr. Manzano at the hotel room at about 4 a.m. on Wednesday morning, then left a few moments later. Manzano of Topeka, Kansas, was discovered dead in the room about 12 hours later because a welfare check was done to see why he had missed an appointment. Anyway, his cause of death as of right now is unknown. Could be completely unrelated to the theft of his wallet. Anyway, what's weird twist here is that Mr. Manzano's 24-year-old wife, Ashley Boyd, had died in a car crash back in Topeka, Kansas, back in April of last year. And his death leaves their daughter now without parents. Sad story. Next, a former California Teacher of the Year cries like a little baby in court as she admits to sexually assaulting students. Jacqueline Ma has been in custody since she was arrested back in 2023. Now, prosecutors claim that she had engaged in sexual relationships with 2 students who were 11 and 12 years old at the time. Now, 2 months before her trial was to take place, Ms. Ma changed her plea to guilty on 2 counts of lewd acts with a child under the age of 14 with duress. She also admitted to a lewd act involving a second child and another count of possessing material containing a minor engaged in or simulating sexual conduct. Now, the crying Ms. Ma sat along with her attorney, letting out a quiet guilty as the charges were read aloud. How did this all come about? Well, back in 2022, the former 6th grade teacher at a elementary school was one of 5 educators named Teacher of the Year in San Diego. And then just 7 months after receiving that award, she was arrested after the parents of the 12-year-old reached out to police to report this suspected inappropriate relationship with Miss Ma. Now, Miss Ma is said to have had a months-long relationship with a boy and sent him rather explicit pictures of her, asking for the 12-year-old to send some of those pictures back. Anyway, it was reported back in 2023. Detectives read aloud the messages between the two in which Ma professed her love for the boy. It's also reported that the child also wrote, "Sometimes I think you don't understand that I'm just a kid still, and this is my only real relationship." As the hearing continued and the investigation went on, they discovered the second victim in this particular case. Now, police had said that Miss Ma used her position to coerce these 2 into the behavior and was beyond inappropriate, beyond wrong. And speaking after the hearing, the district attorney acknowledged that Miss Ma has taken responsibility and is not going to make them go to trial where the children would have to come and testify. Anyway, the consequences of trial would have been much more significant. With this resolution, She is, like I said, sparing the victims from having to come and testify at a jury trial, but she's also helping herself. Why? The remaining charges got dismissed. And guess what? She's only going to spend now between 30 years to the rest of her life in prison, where it could have been hundreds of years to the rest of her life in prison. So at least there's a possibility she could possibly get out of custody. Next on the docket, this day in legal history, 1795. That's right, on February 7th, 1795, the 11th Amendment to the United States Constitution was ratified. This amendment established that federal courts do not have the authority to hear cases brought against a state by a citizen or subject of foreign states. And it was in direct response to a Supreme Court decision called Chisholm v. Georgia in 1793 and reinforced the principle of state sovereign immunity. 1904, guess what? Big fire broke out on this date in Baltimore, destroying 1,500 buildings and causing an estimated $200 million in damages. Significance of this is, well, it forced people to have similar fire regulations and building codes across the city, if not the state, and now these days across the country. On this date back in 1962, the United States imposed a full economic embargo on Cuba, prohibiting all trade between the two nations. And although enacted via executive orders and some legislation, it became the most enduring trade restrictions in U.S. history, and obviously ongoing legal debates regarding the effectiveness, humanitarian impact, and implications under international law. Now, this next one you may say, what? That's right. The Beatles arrive in the United States. Well, what's the legal significance of that, Scott? That makes no sense. Well, obviously, it started Beatlemania, but it also led to a significant battle over music rights, including issues related to royalties, merchandising, and intellectual property that helped shape entertainment law today. And on this day in 2013, the state of Mississippi officially abolished slavery. Well, Scott, that doesn't make much sense, does it? That was abolished right after the Civil War in 1865, did it not? Well, although the 13th Amendment became law in 1865, Mississippi had not formally ratified the amendment until 1995, and the ratification was not officially certified until 2013. Obviously, shows some of the complexities of state and federal legal process and the enduring legacy of slavery. That was a new one to me. I didn't know that one. Who knew? Didn't know. And finally, our dumb criminal of the day. You can't make this stuff up, ladies and gentlemen. So a Florida man was arrested at an auto parts store in Georgia. So he must be there in the panhandle, right? And you may say, well, why? What's the big deal? You can go to Florida to Georgia, right? Well, this guy was in the store barking like a dog for an hour. Well, needless to say, the store employees contacted the police department to contact the male that's been in the store for over an hour barking like a dog. When they arrived, they met a guy by the name of Jonathan Navas, Navas. They asked him what was going on. He responded he had no idea and was surprised that he was causing any issues whatsoever. Anyway, police officers asked Mr. Navas for some identification. He said, yeah, my driver's license is in the car outside. Let's go get it, the police said. When they went to his car, they spotted a clear baggie containing syringes on the passenger seat, one of which was filled with a clear substance, which resulted in the recovery of another baggie. This one contained a clear crystal substance, according to the police. And guess what? It tested positive for methamphetamine. Now, Navas was subsequently placed in custody after getting some more identifying information. They found that he had a warrant in a different state. Needless to say, Florida said, we'll take you back. He'll be extradited upon his release from Georgia. And the other weird thing is they said, hey, what's in that syringe? Mr. Navas said, oh, that's just blood. Anyway, he was booked into the Monroe County Detention Center. And like I said, once he gets his case done there, Florida will take him back. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. Hope you enjoyed the show. Have a wonderful weekend. And remember, the Constitution matters.